Hello, I'm Constitutional Attorney Catherine Henry, and welcome back to part 2 of our Constitution segment recap for Season 2, Episode 23 of Restore Freedom Weekly. We covered the first three cases that were the most important cases of the recent decisions made by the United States Supreme Court. And this section, or part 2 of the Constitution segment recap, is going over the last two, the two a little bit more involved ones that we spent a lot more time on, and we're going to try to squeeze these all into this next 10 minutes here. But basically, there's some surprises in Moore v. Harper. Now, this case was just decided 2 weeks ago, and you would think it would be about gerrymandering or racism or equal protection, but it's not. The United States Supreme Court, in this entire opinion, gives very little time and effort and discussion to gerrymandering or any of that. And what it does is focus on state legislatures, what their functions are, what their requirements and duties are when it comes to Article 1, Section 4 of the United States Constitution. When they're supposed to regulate the time, place, and manner of elections, what does that really mean? And I have some slides in here that I left where it talks about what exactly that does mean. And then a bunch of different things that come out of that discussion with the United States Supreme Court, where the court is saying that it's not just the federal constitution that controls how state legislatures put those regulations into place. No, it's also their state constitutions that control how they put those election regulations into place. So state legislatures have to abide by the state and federal constitutions when they're putting into place election regulations. And therefore, state Supreme Courts then have a say. They have a stake in determining whether a state legislature has gone astray when they are violating, or if they are violating, their state constitutions or state laws. So with that in mind, when you have a challenge that someone raises to how redistricting is done after a census, like as in this case, what the United States Supreme Court is saying is that, well, that state Supreme Court has every right to jump in and answer the question if the issues being raised have any bearing on state law or the state constitution. And that is what was raised here. So with that in mind, I just wanted to point you guys out to a couple of other things. One is the concept of judicial review that the court touches on in a few different places. But basically, the main thing here is that courts of justice, the court is saying, have the duty to declare all acts contrary to the manifest tenor of the Constitution void. It's not just an option. If they see the Constitution being violated, they need to step in and do something. Another piece to this is just the general concept of limits on state legislatures. The court, throughout this entire opinion, is really touching on the concept of the fact that state legislatures are creations of state constitutions, that without the state constitution, there would be no state legislature. And so all powers that a state legislature has really arise out of that state constitution in the first place. And so state legislatures must abide by those state constitutions. They must follow them. They cannot go beyond them, etc. So there is a bad part of this case that seemed to accept and maybe even expand on prior decision that came out of the United States Supreme Court in 2015 when it comes to independent redistricting commissions. But it's basically dicta. It's kind of extra, and it's not a main point discussed here, but it is something I just wanted you guys to be aware of. So I kept it in there nonetheless. So when it comes to, let's see, what are some of the, so basically one of the things that I wanted to point out about this case was when the court is talking about where federally protected rights intersect with state law. Okay, so this could be not just with elections, this could be with anything where you have a federally protected right, but then there's also state law. The state court gets to be involved, and they have a place and a say in how that state law is being followed or violated. But the federal courts can't just back off. They can't have a hands-off approach. No, they have an obligation to ensure that state courts' interpretation of state law do not evade the duties or responsibilities or limitations put on to them by federal law, because federal law and constitutionally enacted federal laws and the federal constitution are what are the supreme law of the land here. So lastly, really I wanted to touch on the private property rights. You wouldn't think in a case about redistricting that they would be talking about private property rights, but they do. So where federally protected rights intersect with state law, again, this case goes beyond what you would think it does. And it touches on a case that it just recently decided as well, I want to say a month prior, in Tyler v. Hennepin County, which is out of Minnesota. It's Minneapolis, actually, I believe was the city she was in. And so the court is saying here that state law is an important source for defining property rights, not a source for those property rights, but for defining them. But at the same time, the federal Constitution provides that private property may not be taken for public use without just compensation. Of course, that's in the Fifth Amendment. So as a result, states cannot sidestep that takings clause by disavowing traditional property interests. And that's a case that's been on the books for 15 years. No, 25 years. I can't even do my math. But it's been around for a while, so it's not a new concept. Basically, you can't have a state government or local government saying, oh, well, this doesn't really involve private property rights. Funny thing is, that's exactly what the city of Ormond Beach is doing to me right now in our case that we have going for our ordinance violation matter. But at any rate, and in fact, the court says that states may not, by ipse dixit, transform private property into public property without compensation. So with that being said, the United States Supreme Court, their final holding on this matter was that state courts do retain authority to apply state constitutional restraints when legislatures act under the power conferred by them to them by the Elections Clause. But federal courts must not abandon their own duty to exercise judicial review. But the case that I spent the most time on, Section 4 of our video parade of information this week, was the Students for Fair Admissions, and that's dealing with affirmative action and Harvard University or Harvard College and University of North Carolina. The court says the admission programs at Harvard College and the University of North Carolina violate the Equal Protection Clause of the 14th Amendment. So this involves two of the oldest institutions of higher learning in the United States. Harvard was founded in 1636, and the University of North Carolina is the nation's first public university. And what is this about? Well, this is all about affirmative action or race-based admissions criteria. And as the court says, these cases involve whether a university may make decisions that turn on an applicant's race. So what the court says here is, I mean, there's just a lot of profound stuff in here, and I hope that at the very least you're going to read all of the quotes that I plucked out and put into the slideshow, but I encourage you to read the opinion for yourself. There's a lot of good stuff, and you don't need to be a lawyer to read it all. So the court says that any law which operates upon one man should operate equally upon all, and that the 14th Amendment will hold over every American citizen without regard to color, the protecting shield of the law. And they continue by saying that for without this principle of equal justice, there is no Republican government and none that is really worth maintaining. The court then does an incredible thing, and it owns up to its prior bad choices. And it says that despite our early recognition of the broad sweep of the Equal Protection Clause, this court, alongside the country, quickly failed to live up to the clause's core commitments. And so they're saying that there's a series of precedent that was bad, and it, in fact, kept the racism and the racial divide going. They reiterate things like separate cannot be equal, and that the Constitution is colorblind. Stating important things like eliminating racial discrimination means eliminating all of it, not just the parts that you think are bad. If you think others are okay because it benefits other groups, no. The court says that their programs that they're talking about here, the affirmative action and admission programs, failed to articulate a meaningful connection between the means that they employ and the goals that they are pursuing. And college admissions are zero sum. If a benefit is provided to some applicants but not to others, that necessarily advantages the people that are getting the benefit and disadvantages the other group, right? It's at the expense of that other group. They're not going to then be admitted because only so many are admitted every year. Harvard's admission process rests on the stereotype that, quote, a Black student can usually bring something that a white person cannot offer. That is literally from Harvard. And UNC is much the same. They have testimony in this matter that says that race in itself says something about who you are. And we're not just talking about a general cultural identity, but about you as a specific individual, and it speaks for you. That is a stereotype. One of the principal reasons race is treated as a forbidden classification is that it demeans the dignity and worth of a person to be judged by ancestry instead of by his or her own merit and essential qualities. But when a university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike. And the university furthers stereotypes by doing this that treat individuals as a product of their race, evaluating their thoughts and their efforts, their very worth as citizens, according to race. And at the heart of the Constitution's guarantee of the equal protection lies the simple command that the government must treat citizens as individuals, not simply as components of a racial, religious, sexual, or national class. Social discrimination cannot justify racial classification that imposes disadvantages upon persons who bear no responsibility for whatever harm the beneficiaries of the race-based admissions program are thought to have suffered. And permitting past societal discrimination to serve as the basis for rigid racial preferences would be to open the door to competing claims for remedial relief for every disadvantaged group. Now, we talked a lot about this, but we're low on time. So just think of some of these other things as well. One of them I want to point out is that the dissent in this case, they're fighting to defend a judiciary that picks winners and losers literally based on the color of their skin. While the dissent would certainly not permit university programs that discriminated against Black and Latino applicants, it is perfectly willing to let the programs here continue. In its view, this court is supposed to tell state actors when they have picked the right races to benefit. That's what the dissent is fighting for. And discrimination is not okay, whether it's to or from any particular race. It's just not okay, period. Justice Harlan knew better, and this is something the dissent and the majority agree on. In view of the Constitution, in eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. Many universities have for too long done just the opposite, and in doing so, they have concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. So, the court has turned down the Harvard and UNC admission programs because of the guarantees of the Equal Protection Clause, and gave some of those specific reasons why. So with that being said, I invite you to check out the full episode that we had. Check out that Wednesday Way to Get Involved challenge and tomorrow's Freedom Fighting Tools for Friday. Thank you so much, everyone. Have a great day. Hello, I'm Constitutional Attorney Catherine Henry, and welcome back to part 2 of our Constitution segment recap for Season 2, Episode 23 of Restore Freedom Weekly. We covered the first 3 cases that were the most important cases of the recent decisions made by the United States Supreme Court. And this section, or part 2 of the Constitution segment recap, is going over the last 2, the 2 a little bit more involved ones that we spent a lot more time on, and we're going to try to squeeze these all into this next 10 minutes here. But basically, there's some surprises in Moore v. Harper. Now, this case was just decided 2 weeks ago, and you would think it would be about gerrymandering or racism or equal protection, but it's not. The United States Supreme Court, in this entire opinion, gives very little time and effort and discussion to gerrymandering or any of that. And what it does is focus on state legislators, state legislatures, what their functions are, what their